defendants discussed with you your living arrangements with the defendant?
I don't remember.
Were you ever told, or were you ever told by your caseworkers that Mr. McTear needed to move out of the apartment?
I don't remember being told that. I know I wasn't supposed to have people living there.
Under the rules for independent living?
Yes.
Okay. And at some point, did you tell Mr. McTear he needed to move out?
Yes.
And did he move out?
Yes.
And can you tell the jury, please, about what time this was? I mean, what period of time? What month or date?
It was right after Valentine's Day.
So you think it was when Valentine's Day, I believe, is on February 14th. Would it have been in February, or would it have been later than that?
Later.
And do you know how much later?
The end of February, going into March.
Okay. When Mr. McTear lived with you in the apartment, did he have his own key?
I think so.
Did he have clothing at the apartment?
Yes.
And after you told Mr. McTear to move out, did he come and get his clothing?
Yes.
And what about the key? Did he return a key to you?
Not willingly.
Okay. But did you meet him at some point, and did he hand a key to you?
Yes.
Between the time that Mr. McTear moved out of your apartment and May 5th of 2009, were there any occasions on which he returned to the apartment?
Yes.
And how would that happen? Would you invite him over? Would he just show up? Or was there phone calls? How did that happen?
In the beginning, we would talk, and I would agree to have him come over. He would ask me if he could come over, and I would say yeah. And then the apartment complex told me that I couldn't, or they would evict me, so I told him he couldn't come by no more. And then he would come by still.
And approximately how many times did this happen, ma'am?
Like 3 or 4 times.
Were there any occasions on which he spent the night?
Yes.
Okay. And can you tell us how many times he spent the night?
Like 2 or 3 times.
Ma'am, I'm going to refer you to the specific date of May the 4th of 2009. Do you recall that date?
Yes.
Did you receive any phone calls during the day from the defendant, from Mr. McTear?
Yes.
And what was the nature of those phone calls?
He wanted to come over, and I told him no, and he told me that he was going to come over and shoot my baby in the face and piss on him in his face, and he was going to kill both of us.
Need a motion, please.
Steve, take our jury out for just a minute. We'll be right back with this quick review.
All rise. Leave your clipboard in your ears, please.
Okay, our jurors, if you can all be seated. Let's ask the witness to please wait outside. Ms. Bedwell, please don't discuss anything about your testimony with anybody from the state or the defense. We'll bring you back in very shortly. Okay, the witness is left. You want some time to discuss what you said?
We would, Your Honor, but before we do that, is it possible to have the court reporter read back the last question that was asked of Ms. Bedwell and the response that she gave so that I have that information for the purposes of our discussion?
Sure, just give the court reporter a minute.
Thank you. We're ready, thank you.
The question was, what was the nature of those phone calls? Answer was, he wanted to come over, and I told him no. And he told me that he was going to come over and shoot my baby in the face and piss on him and in his face, and he was going to kill both of us.
Are you back on? Okay, go ahead. You want to say anything now, or you want to talk?
Nothing further. I have an opportunity to confer.
Okay, go ahead.
Your Honor, I apologize. Are you back on?
Yes, sir.
I apologize for the difficult place we find ourselves in, but we find ourselves in a place where there obviously is significant evidence. The defendant had moved through a motion in limine to appropriately seek to have that testimony excluded. We have numerous orders, a grand total, I think, of 56 separate orders that have been entered in this case, most of them directed to issues regarding evidence. Certain issues that the court has ruled upon have not been covered in the status of the case where we are so far, nor covered in opening statements. The statement that has now been testified to is clearly in contravention of the court's order, which clearly prohibits that question having been raised. It was the obligation of the state to make sure that their witnesses were sufficiently instructed to make sure that those things that had been excluded for the purposes of testimony would not be presented in the course of this trial. There's absolutely nothing that I could imagine that could be done in the form of a curative instruction that could be given to this jury at this point that could cause them to ignore the testimony that is now before the court. I know of no other alternatives that could possibly exist in order to protect the rights of the defendant other than to move for a mistrial of this cause. I realize the significant amounts of time and money and effort that have been placed into the case so far, but there is a clear order that's directly on point with regards to this answer that was given by the witness. It clearly was the obligation of the state to make sure that their witnesses were aware of all orders with regards to testimony, and there's other orders that are in place with regards to Ms. Bedwell and her potential testimony in this case, and so we find ourselves in a position where we move for a mistrial.
Mr. Gale?
And Your Honor, I agree with defense counsel on this position in that clearly this is a violation of the order in limine with regard to that specific statement. And I'm aware that my predecessor on this case did agree not to elicit that specific statement. And when I had spoken to Ms. Bedwell about her testimony today, it was my understanding that that was not going to be her response to that specific question, but that she was going to testify that when she received phone calls from Mr. McTear on May the 4th of 2009 that were threatening in nature. And I think clearly under the case law that would be permissible. Now, this specific statement that was elicited, unfortunately, is the specific statement that the court ordered based on the state's agreement should not be elicited. But, however, with regard to counsel's motion for a mistrial, the state's position is that the defense is not prejudiced because a threat made by the defendant the day before the alleged murder is alleged to have occurred would be admissible under those circumstances, and so a mistrial is not warranted.
Well, are you representing that you would have intended to attempt to elicit this testimony notwithstanding?
Oh, no, sir. No, sir. No, sir.
Even seeking a court's prior approval?
No, sir. My intention was for Ms. Bedwell to testify to a threatening phone call. And this statement that she testified to, Judge, was a statement that it's my understanding was made about a month or so prior as it related to another case involving Ms. Bedwell and Mr. McTear, and wasn't even related to the May 4th incident.
Well, that's all well and good, but it's here in this case and now for this jury. That's my concern.
Yeah, I understand. But as it exists and as it's before this jury, what we have is a threat made by the defendant to the victim, which would otherwise be admissible. It's just this specific statement, which we agreed to previously not to elicit, and it came out in this case, and it was a statement made more than a month prior during another altercation between the two parties.
So what do you suggest we do?
I'm suggesting that the motion for mistrial should be denied because there is no prejudice to the defendant. It's a threat made by the defendant to the victim prior to the murder.
And how do you propose we handle it with this jury?
Well, I don't know that we need even a curative instruction. I don't know what a curative instruction would be.
Well, I know what it would be. It would be worse. Well, as you all know, we spent a lot of time on this case. We spent one entire week selecting a jury. And I had no recall of this when the testimony came out and you objected. I recall we discussed this, and I looked through my orders file. As you indicated, there have been many motions filed, many orders rendered. So some denying the request, some granting the request. But this order in limine reads, and it's dated 1 November 2012, and simply says that the defendant is charged with premeditated murder, burglary with assault, aggravated child abuse, battery, and kidnapping. He filed a motion in limine to prohibit evidence of allegations that he stated he was going to shoot Emmanuel Wesley Murray in the face and piss in his mouth. And as always, I don't consider arguments. I ask for written arguments, but the state, and I guess with your predecessor, Mr. Hart, is that correct?
That's correct, Your Honor.
The state in its written response, which I don't have in front of me, conceded the requested relief, and I relied on that, so accordingly the court did grant the motion in limine and did order that the state not make mention of or attempt to introduce evidence of McTear's alleged statements. And that's dated November 2012. Well, I'm going to do the following. I'm going to send this jury home. I'm going to have the lawyers research this and find out what, if anything, I can do. But it leaves me with, it's all on the horns of a dilemma. One of the remedies is to grant a mistrial and start this all over again. Now, 6 years after the event. Bring the jury out.
Ready, Judge?
Yes.
All rise. Jury in room.
Our jury is back in the courtroom seated and defendant and counsel please be seated. Member of the jury, I want to apologize for bouncing back and forth, but a procedural matter that's going to take considerable discussion between the court and the lawyers has arisen. And the result of that, rather than keep you folks waiting around for an hour plus before we proceed any further, I would like to recess you today. I apologize for bringing you in and then having you leave early. We need to do a lot of talking this afternoon and then some things in the morning, so I'll ask you folks to be here tomorrow. We'll plan on resuming at 9:30. The lawyers and I will be here before then. But my admonition is the same. Please don't discuss anything about the case during the break. And as you may or may not know, I will tell you, as these trials progress, in which there's media interest, there's more and more in the media. So please be very, very cautious about not allowing yourself to see anything or read anything or discuss this case in any way, shape, or form. Again, my apologies for having you recess so early, but drive carefully. We'll see you folks tomorrow at 9:30.
All rise.
All right, jury, so you can all be seated. All right, before we recess, and I say what I need the lawyers to do, is there anything more the state you want to add to what's been said on the record?
No, Your Honor.
Mr. Peacock, anything more?
Nothing further at this time, Your Honor. Thank you.
Okay, let me just make a few observations and comments. First of all, this testimony that came out from this witness in front of this jury was two things. Number one, you've represented that it had something to do with a different case not related to this. Is that correct?
Yes, Judge, and I believe this is the first time it's ever come out with regarding phone calls that were made from the defendant to Ms. Bedwell, specifically on May 4th of 2009, that this statement was made during those phone calls. It's my understanding that in any other previous occasion where this statement has come up, it's been related to something that happened in March of 2009.
So you're representing that, as a lawyer in this case, you did not believe that these statements were related to this scenario, this incident?
Correct, and it was my understanding that was not the answer that I expected Ms. Bedwell to give to that question.
So you believed it had something to do with a case unrelated to this?
Yes, that's correct.
So from your perspective, then, there would have been no reason to attempt to elicit this testimony?
That's correct.
And now, having heard her testify, you believe that these statements were related to this incident, having heard what she just said?
No. Again, Judge, I believe she was asked about a threat, and what I expected her to answer was that there was a threat. He threatened to come over and hurt myself and my baby. And she's confused these threats that were made on May 4th of 2009 with threats that were made previously as they related to prior altercations in March of 2009. That's my belief of what just happened.
So you would not have attempted to elicit this testimony in this case?
No, sir. And I was aware I had discussed with Mr. Hart the circumstances under which he agreed to this motion in limine and agreed not to elicit that testimony, and I agreed.
And that's the reason he conceded. I don't have his response in front of me. He conceded it because it was not, in the state's position, it was not related to this incident.
Well, I think he just agreed in a general way. But my discussion with him was about how it was supposedly related to the prior battery between Mr. McTear and Ms. Bedwell in March of 2009, and the problems with inconsistencies between Ms. Bedwell's testimony about that statement and testimonies by other witnesses about that statement.
The reason I ask this is because absent the motion, absent the state's concession, and absent my ruling based on the concession, I've not yet made a finding, or not asked to make a finding as to whether this testimony would be admissible. There was no need to analyze that because the state conceded it was not going to get into that. But you're representing to me that notwithstanding, had we litigated this, these statements bore no relationship to this case. They had something to do with some other matter. Is that correct?
That's correct.
All right. Well, that's all I need to know. Mr. Peacock, anything more you want to add to it?
I would just briefly add at this point and reserve the right to comment on it further. I believe that the statements did initially arise or potentially arise in the case in which Mr. McTear has previously been tried and found not guilty, quite frankly. The words that were used are words that have continued to be repeated in this case, meaning the case that's currently before the court. And we have statements at this point from 200 witnesses, and whether that particular language was stated by witnesses following the time of the death of Emanuel Murray Jr., or whether it was stated contemporaneous with it, or whether it's related to factors leading up to after the time of the March incident and leading up to this case, is greatly irrelevant. The significance of the testimony is the overwhelming nature of the allegations, which is the reason for the motion in limine in the first place, to make sure that it wasn't part of the trial. And Mr. Hart agreed with that, quite frankly, and I don't think his agreement, with all due respect to Mr. Teal, was intended to be limited to references to that statement having been made in a prior case. I believe that when we discussed this issue, the decision was that it had no bearing and was inappropriate, and the court ruled that it was not going to be admissible, essentially in any form in this cause. And now it's out.
Well, I will say I do now have in front of me the state's response by Mr. Harb dated May 9 of 2012. And Mr. Harb, as we know, there are many cases, but these statements, which are now before this jury, regarding shooting little Murray in the face and piss in his mouth, the state of, I'm reading the conclusion to Mr. Harb's response. And he says, the state of Florida concedes that any evidence of the defendant's threats which were made on March 31, 2009 are not relevant. So these statements that are now before this jury, and what the jury understands is that these statements were made this was a May incident, was it? May?
That's correct.
So what's before this jury is that he made these statements on May the 4th, 2009. But Mr. Harb's response references these statements as having been made March 31st, 2009. Does that date mean anything to anybody? March 31?
The date of the case that was tried to the jury in which Mr. Richard was found not guilty, Your Honor.
Correct. And Judge, now that I recall, I was asked to file a second response to this motion, which I did under my name, basically using the exact same language that Mr. Harb had, dated the 3rd of October of last year, 2012. And I agree.
Mr. Harb goes on to say in his response that wherefore the state prays that this court grant defendant's motion in limine with regard to allegations that the defendant stated he was going to shoot Commander Murray in the face and fist in his mouth. However, and although unlikely, should the state of Florida decide to present any evidence of those threats, will seek a prior approval from the court. Anything else?
Well, any further, based upon that, Your Honor, I would just ask once again that the mistrial be granted. I'll be glad to provide additional information to the court if the court seeks additional information.
I'll give you gentlemen and ladies till tomorrow morning to come up with anything that you can come up with. Let's us meet at 8:30. The jury's coming here at 9:30. But you all know what this looks like. We'll be in recess tomorrow morning at 8:30.
Yes, ma'am.